All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have two cases on the calendar this morning, and we'll take them in the order in which they appear. The first case is Victor Coley versus United States. Counsel?
Good morning. I'm Cecilia Englert, and I'm here on behalf of the appellant, Victor Coley. I'd like to reserve 5 minutes for rebuttal argument. Mr. Coley's legal arguments are set forth in the written briefs. I'd like to emphasize two general points. First, that it was the government's misconduct that caused the jury to be dismissed. The government selected the jury knowing that it was withholding evidence from the defense and that it had a witness only testify if the trial was not delayed. And the defense received new information as the jury was waiting to enter the courtroom. And the government put the defense in the position of either having to give up the jury that it had just selected or giving up adequate time to review the information that it had just received. This was manufactured by the government and it was 100% avoidable.
What do you think the government's intent was? Do you think this amounts to bad faith?
The government had plenty of notice that DFS was under investigation. Enough notice that it got its own a second expert to give another opinion. It could have much earlier than it did filed its ex parte motion to the court rather than the day before jury selection. And because jury selection was going on, it appeared that the trial court was busy jury. And in part, it was in a hurry to select the jury because the witness that needed to testify that Tuesday because he had surgery the next day.
Agree with you. I'm sorry for interrupting that. Obviously the trial judge was pretty annoyed with the prosecutor and, this is less than ideal the way this all played out, but how does that translate into a legal error that can get your client the remedy you seek without jumping through the double jeopardy hoops? Are you sticking with your first issue now and saying that the jury that was going to hear the case didn't need to be sworn to, for double jeopardy to attach?
Well, I think the argument is that there are several layers of argument. Number one is that it's true the Supreme Court cases on double jeopardy have dealt with the swearing of the jury, the petty jury. There isn't a case directly on point where the Supreme Court has addressed whether or not the swearing of the jury is the venire or the petty jury. Now there are, as I had put in my briefs, there are circuit court cases that directly address this because it appears that this argument has been brought up in the courts of appeal, but not directly in the Supreme Court. And so there are courts of appeals who have directly ruled that it is the swearing of the petty jury.
Can I, just before you go on, I'm sorry, just to make sure I understand your argument. Is it your position? I mean, we've got the DC Circuit case, and I think it's Green or something way back in the 70s, basically deciding this issue. Is it your position that the DC Circuit was misinterpreting the Supreme Court's language, or is it your position that different jurisdictions, although of course this would be the same jurisdiction, can interpret that language differently, because it would be kind of odd if it's one way or the other. And we've got cases from the 70s saying it means the petty jury needs to be sworn. It would be kind of odd to think that was wrong after all these years.
The different the DC Court of Appeals, as far as I have not been able to find a case directly on point. I would like to also call the court's attention to this importance of the swearing of the petty jury as the point, and I guess this position that it's an immovable point at which jeopardy applies is, I think, eroded by the cases that allow a conviction despite a late swearing of the jury or no swearing of the jury. And I don't think that the Supreme Court has taken this issue head on. And a lot of the cases that you see do lean on the side of jeopardy attaching. These cases were trying to push the attachment in a way that would disfavor the defendant. And so the Supreme Court, my reading of the cases are that the Supreme Court has pushed against that and has not directly addressed this issue with whether it's the precise, it has to be the swearing of the petty jury, and addressing the fact that some of the circuit courts have allowed convictions to stand despite a late or no swearing. I would also like to call the court's attention to the fact that the trial court would have sworn the jury, but for the government's intervention. Towards the end of the day, most of the jurors had been selected, and the trial court had said that it was ready to select the alternates, swear the jury, give them some instructions, and dismiss them for the day. And so the trial court had already indicated its intention to swear the jury, but the government intervened and asked the court not to swear the jury. And so the jury was given instructions and then dismissed that day without being sworn.
You know, I had thought at one point that your argument focused on Mr. Coley's having to give up the jury that had been selected. Was a separate argument, sort of a due process argument, separate from the double jeopardy argument. But I guess the way you put it just now, and I was just looking back at your brief, I guess in your view, it is still attached to the double jeopardy argument. It's sort of part of the reason why putting someone in double jeopardy is bad, is wrong. Is that right, or are you making a separate argument?
It is, well, the answer it is part of the same argument. And I think that double jeopardy law has been a bit messy because jeopardy used to attach after a verdict, and then that line was moved back through many years. And I think different cases have emphasized different aspects of why jeopardy attaches. And one of those is the valued right in being tried by the jury that was selected. And I think that was emphasized in Christ. And so I think that it has been encompassed. Both of those reasonings have been encompassed into double jeopardy. I don't know that there's a separate due process right but it seems to be, and it has been viewed as a valued right as part of double jeopardy.
If we conclude that jeopardy never attached in this case, because jeopardy does not attach until the petit jury is sworn, where does that leave your argument about the, what you call the government's misconduct in failing to disclose earlier the problem with the forensic center?
Well, I think that a lot of the cases that deal with disbanding the jury without a verdict is instructive in this case. That what we're arguing is that we're arguing against the position of throwing out everything unless that exact point of swearing the petit jury has been reached. And so the government misconduct plays into everything that has happened in the trial, that the government shouldn't be able to do whatever it wants right up until as long as the jury isn't sworn. And so the Supreme Court has said, and it doesn't allow the government to retry a defendant where it realizes, when the government is selecting a jury, knowing that its witnesses are not there. It's not allowed to go ahead and select the jury, knowing that the trial cannot go forward. And so that is what has happened in this case because of multiple steps that the government did have control over. And that was disclosing the evidence. It knew the fact that its witness would not be available, and it asked the court not to swear the jury.
What do we do with the fact that counsel for your client, Mr. Coley, once the situation was being discussed among the judge and the parties, it became clear that he was interested in the same witness who had the surgery scheduled. And he, I think, may have actually ultimately requested to discharge the jury that his client wanted and take the continuance. If he's the one, if defense counsel is the one who kind of asked for this outcome, why isn't that problematic?
It's because he was put in that position exactly because of all of the government's actions. A person shouldn't have to choose between retaining the jury and deciding, saying, well, if I go ahead with this trial, I will not have reviewed the stack of documents I just received. It's not a position that the defense should have been put into. And so it was not a free choice for the defense.
I take it the defense is not able to make any proffer about there being anything in that stack of documents that in fact could have been helpful to the defense had the trial gone forward?
I'm sorry, Judge Glickman, I didn't hear the very first part of your statement.
I take it that this is not a situation where the defense is able to make a proffer that now that we've gone through those documents, we can see there was helpful evidence in there that justifies or that explains why this was such a serious problem. and why we couldn't just go ahead with the trial.
That's correct. Defense counsel asked to view the documents just overnight. So defense counsel asked the court to recess for the day so that he could go through the documents and at least make a preliminary determination whether the trial should go forward or not. So defense counsel was prepared to quickly look at the documents that day.
Well,
And
refresh my memory. Didn't the judge go along with that request?
the judge was about to grant that request. And at that point, the government did everyone that it could not continue the trial to even the next day, because the next day its witness had surgery. So-
Yeah, well, actually, that gets to something that puzzled me a little bit, which was how they could have gotten to that witness in time for the surgery, or in time to get the witness off the stand for the surgery in the short time available. Would that have been possible
I would
under any
speculate,
circumstance?
I would speculate that perhaps that witness would have gone first, could have gone first. But that's speculation on my part.
You know, Ms. Engler, you certainly are correct in your citations to the case law, Supreme Court case law, and our own that talk about the valued right to be tried by the jury that was selected, or by a particular tribunal, I think is the language the Supreme Court used. So that's important language. We're bound by it. But I have to say, it doesn't resonate much with me because of what we all know about how juries are selected, how counsel run out of peremptory strikes. In other words, the jury that one has selected isn't necessarily the jury one wants. You know, it's the jury where you've sort of made the best of the limited options available to you and tried to get stricken for cause jurors in whom you can perceive some problem. And, you know, you have your couple of peremptory strikes and you end up with the jury, and it's not necessarily the jury that you want. On the other hand, what the court has said about the continuing stigma of being accused of wrongdoing and a delay in the trial just resonates more with me if I were called upon to describe what's wrong with what happened here in terms of causing everything to be delayed. So I guess all of that is just a preface to a question to you is, can you help me understand better these references in the case law to the jury that was selected? Why is the particular jury that has not yet been sworn and that has not heard any evidence and reacted to it, why is that such a valued right? As I say, I acknowledge that the cases say that and we're bound by it, but why is it? Enlighten me if you could.
Well, everything you said is I have to agree with. But I think when you talk about the valued right of the jury, that encompasses as well all of the stigma that happens. Now, for Mr. Coley, he had already gone through a full trial, and this was a retrial, and they went through the whole selection of the jury. When he came back to court, he expected to have that trial and have his day in court and have his guilt or innocence be determined. And now the government seeks to put him through yet a third jury selection. And so this is something that has dragged on for him. And, you know, that burden and stigma and stress, which it is for defendants, has dragged on for years and years and years and need not have.
May I ask, have you come across any case where government action, or however one characterizes it, results in the judge having to discharge the veneer and abort the proceedings before the selection, before a petit jury has been sworn in which that has resulted in any sort of relief for the defendant?
I have not come across a case misconduct during the during voir dire. I can't say that I've come
I
across.
mean, there are the delayed disclose. There are the cases in which Brady material is disclosed untimely, but before trial. But those cases turn on whether the delay in disclosure has prejudiced the defense. The time, whether this really was untimely or not, in effect, you could say. The mere fact that it might delay the trial, that might be typically the relief that is granted for a delayed disclosure. But it's not itself viewed as something that, at least I'm not aware of, that it is viewed as something that for which the defendant is entitled to some sort of relief. Leaving aside situations, I suppose, where the defendant has been held incarcerated and there are time deadlines and the like, and the judge adjusts the conditions of release. You see, what I'm getting at is whether if we take out the double jeopardy component of your argument and just look at the facts as they are without the notion that jeopardy attached, I'm wondering if you have any case law that really supports your position here.
I haven't run across anything that I can cite to the court. I think because these late disclosure cases usually result either in a continuance that's granted or...
But you can imagine the defendant in those cases saying what you're saying. A continuance doesn't really rectify this for me, because I really went through this jury selection process and have selected the jury of my dreams. And I escaped a lot of bad jurors being on through good luck and whatever. And now I'm losing that jury. Now, one thing the defense could do is say, well, Judge, I want to keep this jury. Let's just keep them on hold for a week or two or whatever. And they'll cool their heels and we'll then go to trial. That, I take it, was not done here because there was no certainty as to how soon the witness that everybody wanted, who was going in for surgery, would be available, right? So you couldn't really, I suppose, keep the jury waiting indefinitely until you knew. But you see the issue I'm getting at, which is, we have a bright line that most courts appear to have accepted, which is that jeopardy attaches only when the petit jury has been sworn in. If that had happened here, then we'd have an issue about whether the defense was forced into requesting a mistrial by bad faith government action or what have you. By the way, I take it you don't really have do you think you have a showing of bad faith here on the part of the government?
I think the bad faith comes from trying very hard to withhold the evidence from the defense, to the point where the government was asking for the court's protection in order to continue withholding the evidence.
That assumes it actually was exculpatory in some way or helpful to the defense, which gets back to a question I asked you earlier, and I think that's not entirely clear. And certainly the government maybe they were late, but the government did present the issue to the court. So it's not like they're just concealing this stuff because they know it would hurt.
The government, although defense counsel wasn't able to review complete everything that was in the stack of documents, certainly the defense could have made something of the fact that DFS was under investigation and that the person who had testified previously in Mr. Coley's previous trial was involved in this investigation.
Well,
So-
I wonder if that's true. I don't, it's not obvious to me that there's enough here to justify that kind of impeachment type cross-examination. Did the investigation have anything to do with the examination of the weapon in this case?
Yes, if I,
Oh, I was under the impression it didn't. I was under
there was a, in the first trial, Mr. Pope testified that the shell casings were fired by the gun that was found in the apartment Mr. Coley was seen coming out of. And
Right,
so,
but to the alleged wrongdoing, maybe you may be able to tell me something important here. I may have misunderstood. Did the alleged wrongdoing that was under investigation at DFS have anything to do with the examination of this particular weapon?
not as far as I know. But it did have to do with Mr. Pope. The investigation did implicate Mr. Pope, who had testified in Mr. Coley's trial.
Right, but merely because Mr. Pope was being investigated for some other unrelated wrongdoing at his job, I'm not sure that would be something that could be used to cross-examine him at the trial, absent other facts that could make it very relevant, I understand. That's what, but, okay, well, I think we've gone over your time limit, but we will give you 5 minutes for rebuttal as you requested. Let us hear from counsel for the government. Ms. Park?
Good morning, Your Honors. May it please the court, Ann Park on behalf of the United States. It is undisputed that the jury selected to try the case was not sworn. Therefore, jeopardy did not attach, and the double jeopardy clause does not bar for trial. That ends the inquiry, and this court doesn't need to address appellant's other arguments. The Supreme Court stated in Martinez, there is no ambiguity in the case law. Jeopardy attaches when the petty jury is sworn, and the Supreme Court stated that there are few, if any, rules of criminal procedure clearer than the rule that jeopardy attaches when the jury is impaneled and sworn. And the Supreme Court's own cases, Christ v. Brest, Downham v. United States, Illinois v. Somerville, make very clear, as well as a Green case from the DC Circuit and the other federal courts of appeal that we've cited in our brief, that impaneled and sworn refers to the swearing of the petty jury and not the swearing of the venire panel. It's a bright line rule, which Martinez makes clear. And there was argument actually in Martinez when I was reviewing the case. I think the one party suggested that there should be some sort of sliding scale, and the Supreme Court rejected that. It is a bright line rule, and there's nothing wrong with either the prosecutor or the judge understanding that jeopardy attaches at the moment the petty jury is sworn and putting that off. That happened actually in Martinez, and the Supreme Court didn't say anything about any sort of misconduct by the court or the prosecutor. Everybody knows it's a bright line rule, and that is why the prosecutor asked for it to be held off, because nothing was going to happen in the next few days. The next day was a Friday, court was in session for the jury. The following Monday was a holiday. And so there's nothing nefarious about the prosecutor's intent in asking that the jury be held off.
The prosecutor didn't want the jury to be held off. The prosecutor has this important witness who, if you hold it off, the prosecutor is going to lose that witness.
Yes, Your Honor. But I think the prosecutor made very clear, the whole issue of Mr. Foster, if you actually look at the record, the trial was originally supposed to start November 12th. Then there was, in the docket entries, October 29th, the government moved to change the date to November 7th. And that is start jury trial then. That's because there was concerns about Mr. Foster's surgery. So this was all this to say, this is all kind of aired before the November 7th date of picking the jury, or before the prosecutor filed its ex parte motion for a disclosure order. I think the important point here is when we're talking about misconduct, we are here on an interlocutory appeal, which is very limited grounds for appealing on a double jeopardy claim. And in the double jeopardy case law, I don't think it's unclear at all. Jeopardy attaches at the moment the jury, petty jury is sworn. And even assuming that it does attach at that point, even if we assume that it attached here, appellant's consent removes any barrier to retrial. And this court has stated numerous times in Carter and other cases, and that's even if the prosecutor's error or judicial error necessitated mistrial. And there are limited circumstances when consent does not, this court has noted very narrow exceptions to the rule that a defendant's consent removes any double jeopardy bar to retrial. And that is when the prosecutor intended to provoke the defendant into moving for a mistrial. And the court has called it prosecutorial goading. In Fletcher, the court said that you have to show intent is a key point to eviscerate consent in this context, and you have to show the prosecutor's intent to subvert the protections afforded by the double jeopardy clause.
Is it always, those are terms that are sort of on one end of the continuum in the case law. I've also seen, terms like overreaching that don't seem quite as serious. And is it arguable that this wasn't consent at all, because he was just dealing with the situation as the government created it, and trying to pick the best option after that?
No, Your Honor, and that's because, I would point, Your Honor, to the November 12th transcript, and it's very clear, pages 44 to 45, and this is appellate's appendix, pages 146 to 147. It's very clear that the court presents it to appellant as his choice. He's not going to listen to the government at this point. He basically says, look, you got this information. I'm not going to make you go to trial. And you have to decide whether you want to go forward or not. And defense counsel states, I understand. The court needs to hear from the defense whether the defense elects to go forward, knowing what we know, or whether the defense is saying we need to call a witness, or we need more investigation and we need to dismiss the jury.
How is that a choice if I'm sorry for interrupting, but if
Sure.
he wants, the only reason this is all happening is that in order to competently represent his client, he needs more time to absorb the documents that have been handed over. So, he's choosing, but he's like choosing from a world that's not the world he made.
Sure, Your Honor, and that happens a lot in trials. Your defendants are often faced with less than ideal choices, as is a government. But in terms of, is this intentionally trying to get him to move for a mistrial? Is this misconduct the double jeopardy clause is trying to protect the defendant from, like multiple, prosecutions, or having the case previewed so the defense for the government gets an advantage somehow? And the answer is no, because in Lee Thomas, the court made clear the double jeopardy clause did not bar retrial defendant, where the judge made clear that the choice to continue rested with the appellant. That's in quotes. Although defendant may have been faced with two options that were both imperfect, he still retained the ability to choose between them. That seems to me to be clear that that sort of choice, the less than perfect choices that appellants and litigants are often faced with in trial, that is not the kind of conduct that's going that the appellant was somehow forced into making a mistrial. The standard is very high. This court's cases make very clear, and Oregon v. Kennedy, the Supreme Court case, makes very clear that to eviscerate consent in this context, the double jeopardy context, misconduct is not just what seems everybody's talking about here, Brady misconduct. We are not talking about that. We're talking about a specific type of misconduct related to the double jeopardy clause, and there's no evidence of it here. The prosecutor the prosecutor, when trying to explain why he did not disclose this or wanted a protected order not to disclose this to the DFS, basically told the court, look, there's an evolving, very sensitive and serious investigation into a very recent allegation made by a former DFS employee, and that investigation needs to be protected. I mean, as the government was making these disclosures, interviews were actually being conducted. We're talking about the first month of investigation, the very preliminary stages. They didn't know certainly the magnitude of what they were going to find. We all know now with hindsight, but they didn't know at that point. There was no, he wasn't dragging his feet to manufacture a crisis to gain an unfair advantage. This was just all going on in real time as it was happening.
But the prosecutor's assumption must have been that this, and in fact, I think this was said in some pleading, that this information was not important to the defendant, who's picking a jury. And the trial judge obviously disagreed with that. I think the prosecutor wanted to say ahead of time, well, this wouldn't end up being material because we have this new guy. But the judge disagreed with that. And I'm not sure I hear you disagreeing with the judge.
That is a judge's order. And he reviewed the evidence. This is why these procedures are in place. The prosecutor did exactly what he should have done. That is, he didn't think it needed to be disclosed, but it's the judge's duty or job to review the documents, and the judge clearly believed it should be disclosed. But I think the important point here really is we're looking at a claim of a violation of double jeopardy, and it is a very specific claim. And a lot of the conversation about misconduct, the term is being thrown around kind of loosely. And those are all issues that very well may come before this court after the defendant, if he's convicted, and gets his chance to appeal those issues. But they are not. This is not the place to kind of dredge them up here, because the record isn't there for them. And all the court needs to figure out really is, did jeopardy attach? If you're not going to, if you don't believe jeopardy attached, then we have consent. Appellant clearly, on the pages of the transcript that we, cited to in our brief, he clearly asked for this. And he not only asked for it, he said, well, look, I've thought about it. It would be a disadvantage for me as well not to have Mr. Foster. Here are the reasons why. I don't know what I'm going to do with all this material. I need to figure out how I want to use this in the case. So we're going to ask for a continuance. And even if the court—
I'm sorry, can I, before you get too far afield from the—
Sure.
Talking about what would happen in the next trial. This is sort of an aside. This is a huge aside. It's not a legal issue on appeal, but it's kind of percolating everywhere that I have to ask about it, which is I'm looking at Mr. Pope's testimony, where he testified at the first trial that, there were 6 casings. He said they were fired from the gun that was found, and that's associated with Mr. Coley. And in the closing argument, the prosecutor also said it was a match. And now the government is offering this new guy, Mr. Spinder, I think it is, Travis Spinder, who the government represents, is going to say the exact same thing, which is to say this, the ballistics show that these shell casings came from this gun. Why doesn't that testimony run afoul of, Marlon Williams, our case law about, experts giving that sort of testimony that says this was a match? And I know this isn't here. It's so much in this case that we're arguing about these 2 experts that I can't help but wonder, is this guy actually going to testify at the second trial?
Your Honor, unfortunately, I don't not have an answer for that question. And it's because I didn't prepare for, talking about that far into the issue of the experts, because we are here.
Understandable.
So I don't want to start talking about things that I haven't researched, or I could be completely wrong on, or don't have a grasp of the record, because I've not looked through the trial transcripts that thoroughly. And that just leads me back to this case, and it really turns on whether jeopardy attached or not. And even if it did, his consent removes any constitutional barrier to retrial. And if the court, wants to apply the very limited narrow exception that has been identified, and I'm relying on Speaks and Fletcher v. United States, there's just not that kind of evidence here. There's been no finding of prosecutorial misconduct in this case whatsoever, certainly not related to double jeopardy. And there hasn't been any found related to Brady, because that issue hasn't worked its way through yet, because appellant filed his motion about a week, his notice of appeal in this case, about a week after the court denied his double jeopardy motion, and it's been an appeal here. So there's been nothing going on in the trial case court below. That's all ready to be decided, but this is not the time or place to decide it. And the law is very clear on this issue, and we'd ask that the court affirm the judgment of the Superior Court.
Thank you. Ms. Englert, we have a few minutes for rebuttal.
Sorry, I had to try to unmute myself. Just a couple of brief points. One of the cases that the government cited, Lee Thomas, where the defendant chose a mistrial. That was a case where the trial had already taken place. The evidence was in, and the judge indicated that I think saw some problems with defense counsel, and the judge indicated that he thought there was going to be guilty verdicts up and down, and gave the defendant the choice of asking for a mistrial. And this was a choice where the defendant had some benefit. And in our case, what we have is a situation where the defendant is boxed in on all sides by the way the government has proceeded. The normal relief to getting evidence so late would be a continuance, but that wasn't possible because of this witness.
Well, it was possible. That's the relief that was given here.
Right. Without giving up the jury.
Well, but it's often the case that, things happen at trial, and the defense or the prosecutor or a party in any litigation has to make a choice where that they would rather not have had to make, and it's a choice where neither option is perfect. That doesn't, that's just the way life is. Life in our courts, life everywhere is.
Yes.
And how do you respond to Ms. Park's argument that this is an interlocutory appeal and it is strictly limited to the question of whether there's been a double jeopardy violation, and all other issues are simply not appropriately decided in this appeal at this time?
Well, the court, traditionally on appeal, the court can rule on any matter that is supported by the record. And
well, that's a little broadly stated. I'm not sure that's not too broad. Normally you can't take an interlocutory appeal for issues of prosecutorial misconduct or whatever you want to call it, Brady violation or whatever. You can't raise those issues on appeal interlocutorily. You have to wait until the trial is over with, and if you've lost the trial, then you can raise them on appeal. The exception is for a claim of a double jeopardy violation, because if there was such a violation, then that means the defendant has a right not to be put through all the other stuff of the trial. So we do need to ask ourselves, was there a double jeopardy violation here? But Ms. Park's point is that if you conclude that there was not, that's the end of the inquiry, and you send it back for the rest of the proceeding to go forward. And I'm wondering if you disagree with that, and if so, whether you have case law that would support it.
I don't have case law on hand to say that the court can rule on something completely separate in an interlocutory appeal, but I don't, I just don't know that off the top of my head. I would like to leave the court with a quote from Downham, which states that we resolve any doubt in favor of the liberty of the citizen rather than exercise what would be unlimited, uncertain, and arbitrary judicial discretion. And that comes from Supreme Court case Downham dealing with double jeopardy issues. And I would like to close by saying that Mr. Coley had a valued right to be tried by the jury that he and his defense attorney selected. And the government should not.
If that right doesn't come when double jeopardy attaches, and because double jeopardy attaches, where does that valued right come from?
It has been wrapped into double jeopardy, and that would be this would be Christ versus.
Well, I know where the language comes from, and I know that I understand the case law associates that with double jeopardy. What I'm saying is, if double jeopardy does not attach until the jury is selected and sworn in, why does he have any valued right at this stage before the jury was sworn in?
The burden on the defendant it doesn't change with just the swearing of the jury. The whole stress and the
That's true. Well, I mean, that's certainly true. But again, the fact that, the defendant's been forced to go through the stress of coming to court, getting his hopes and fears aroused, facing the judge, going through the entire process of the jury, being selected, the veneer examined. Yes, I can understand that is stressful, but I don't know if that's to say that. I'm not sure if that is saying anything about whether there is a valued right to have that jury selected and to go with it, just to be able to. Because if there's a right, what that right means is the defendant can say to the judge, regardless of what the government says about this bad stuff coming up, you must swear in this jury, and we must go forward. Or you can just let me go and drop the whole thing. That's the option. So it's consequential, it seems to me, to say there's a valued right at that point. And I'm not sure there's any authority for it or where it comes from.
Well, then I would also turn the court's attention to cases where the actual swearing of the jury has not prevented, or the lack of swearing a jury has not prevented convictions from standing. And other courts of appeal have upheld convictions despite late swearing or no swearing of the jury at all. And so if that is the point of determination, then that's something that the Supreme Court has not looked at in conjunction with double jeopardy. If you allow a conviction to stand when there has been no swearing, how can you say that jeopardy hasn't attached at that point? And with that, unless there are any other questions, we would submit our case as well in the written briefs.
Okay, thank you, counsel, both of you. The case is now submitted, and you may log off.
Thank you, Your Honors.
Thank you.
We will call the second case on the calendar, John Kenny versus Rockwood Mayflower Incorporated. Good morning, counsel. If you're ready, we will proceed.
Good morning. May it please the court, I'm Paul Zuckerberg, representing the appellant. It's within the everyday experience of jurors that an unlighted staircase creates a danger that someone will fall. And the conclusion is that it's more likely than not that a fall would not have occurred except for the lack of lighting. In this case, viewing the evidence in the light most favorable to the appellant, the lights on this staircase were out, were not on, and the staircase was dark, and as a result, he fell. We argue that the trial court erred in entering summary judgment requiring expert testimony on this issue because it's within the ken of the average juror.
Why do you, I'm sorry, Mr. Zuckerberg, why do you say we have to assume the staircase was dark? It seemed like something that was argued over in the briefs. Your opponent, took a position that a lot of the case law that was being cited was for completely dark staircases. And this one, I understood the allegation to be that there was light at the top and dimmer light at the bottom. What is the actual evidence on that?
Well, the evidence was in the interrogatory answers. The plaintiff testified that the lights were off and the staircase was dark. In his deposition, he also said that the lights were off and the staircase was dark. It was an L-shaped staircase. There were two lights. There was a top light at the top, which apparently was on, and the light at the bottom of the staircase was off. So viewing that evidence in the light most favorable to the plaintiff, the light was simply off. This is not a case where the plaintiff is saying the lights were on, they were functioning properly, but the lumens were not sufficient, which would require expert testimony. This is simply a case that the light was off. It was not on at all, and therefore it was dark.
It's black.
Okay, the briefs though refer to the lower staircase being dimly lit. Is that not something that your client said in his deposition? Where did that phrase come from?
Dimly lit was, there was light from the top, the light that was at the very top of the staircase. In other words, it's an L-shaped staircase. The light at the top of the staircase was on. As he walked further on, it became darker and darker. And he used the word, he testified it was very dark. There was only one light, and that was at the top. It was dimly lit. It wasn't lit up. There were no lights on. That was his testimony. So at the bottom of the staircase where the fall occurred, the light was off. And it was subsequent investigation revealed that that lower light could not have been turned on from the top of the staircase. In other words, the light on the top of the staircase, there was a switch, but it only turned on the top staircase light, so that the bottom of the light, the bottom light, which illuminated the bottom of the staircase where the fall occurred, was off, completely off. That is what the testimony was. And the only light was whatever could have reflected down from the upper staircase. So at this point, it must be viewed in the light most favorable to the appellant, which is that the light was off and it was dark.
I'm thinking about how that works if your client actually articulated the words dimly lit. does viewing the evidence in the light most favorable to your client require us to assume that the lower staircase was dark? Is that what,
That's
is
what he
that what you
testified.
said?
The
I
room
thought
was
you
very
told me
dark.
that he used the phrase dimly lit.
It was not absolutely black. He did use the phrase dimly lit, but he explained quite clearly the room was dark. There was only one light and it was dimly lit. You could not see very well. It wasn't lit up. There were no lights on. So the light, at the bottom of the stairway was off. It was just a light that had not been turned on and it was dark. And that's what he testified to. He said the room was dark. And I'm quoting from 140 of the joint appendix. The room was dark. So I think if it had been lit up and if there had been light, I would have seen the other step. So it's pretty clear that the light was off, and when lights are off, it's dark. It wasn't, there was some ambient reflections from other lights that, filtered in, but the overhead light above the stairs that was illuminating the staircase above him, the bottom of the staircase, was clearly testified as being off.
So if we accept, I just want to understand how this works. So if we accept that it wasn't pitch dark, but it was dark, it was dim, and Mr. Kenny says, for me, it was too dark and I missed the staircase. How do we know that? How does he establish that it follows that the hotel breached the duty of care in allowing the light to be at that dim, not totally dark level?
It was off. I mean, the staircase light was off.
The bulb in the ceiling at the bottom of the staircase was not turned on, right?
Correct.
But it wasn't totally dark. It was dim. Maybe we could say it was very dim. Mr. Kenny would say it was very dim, whatever very means. How do we know? How does a jury know? When I say we, it's real. How does a jury know that that dimness was a breach of the hotel's duty of care?
Well,
I mean,
because
is there some law that says lights have to be on in the ceiling? I sort of doubt it. And Mr. Kenny's job is not simply to say it was dim and I fell. He's got to say it was so dim, the hotel knowingly left it so dim, or negligently left it so dim, that as to breach a duty of reasonable care.
it's common sense that you have to have the lights on in the staircase. You can't have the
You
lights
you
off.
sort of say, well, I don't know if that's common sense. You're sort of saying that the fact that an accident happened is proof that there was negligence, which I don't think is quite a it gets you where I don't think that argument gets you where you need to go.
I mean, if you look at Prosser and Keaton, who I quoted in the brief, and they say it's within the everyday experience that unlighted staircases create a danger that someone will fall. When a person falls in an unlighted staircase, it's reasonable to conclude that it's more likely than not that the fall would not have occurred but for the bad lighting. That's black letter tort law. In fact, Prosser and Keaton use that as an example of the type of evidence that you don't need expert testimony for. It's common sense. They led this tour group down a staircase where they had not turned on the lights.
It's easy to agree, I think, that if the staircase were totally dark, like a closet when the door is closed or something, that a jury could readily find that a duty of care had been breached. I think the problem seems to arise where we are given to understand it wasn't totally dark. there was a low level of light. And this is common experience that people often find themselves in places where there's a low level of light. So I sort of wonder whether one can really say that if all you know is that there was a low level of light and Mr. Kenny tripped, that is enough for a jury to say that the hotel breached its duty of care, and that there was a light in the ceiling that could have been on, that the hotel could have turned on, but they didn't.
Well, you have an L-shaped staircase. You have two lights, one at the top and one at the bottom. It's reasonable to believe that there's two lights there, one to illuminate the top of the staircase and one to illuminate the bottom. And if the bottom light is indeed off, there's not going to be illumination at the bottom of the stairs, and that the light coming from the L-shaped staircase at the top is not going to be able to sufficiently illuminate the steps at the bottom of the staircase. That's why there's lights at the top and the bottom of the staircase. This is within the common experience of the jurors. And this is what the jurors are able to listen to the testimony and to make that determination. You don't need an expert witness to say that if the light is off. And in fact, their expert report said that if the light had been on, there was sufficient illumination. But you don't need an expert to say, obviously, if the light is off, if it's not turned on, there's no overhead illumination. And this is within the realm of the average juror to be able to reach that conclusion without having an expert come in and measure the lumens of a staircase with the light is not on.
Mr. Zuckerberg, can I ask you to clarify, just clarify one fact, which is the reference to dimly lit. Does that mean the light at the top was dimly lit, or does that mean the stairwell overall was dimly lit?
You know, it's unfortunate that he used the phrase dimly lit. I think the testimony as a whole, the light was off. That is the key characteristic, that the light was off and it could not have been turned on from the top of the staircase. So it was off. It wasn't completely hermetically black like the universe, the distance of the universe where it's black. But he testified that it was dark enough so he could not even see or describe the staircase. He was asked, can you describe the staircase? He says, not really, because it was dark. It was too dark for him to even be able to see and describe the staircase. And you could imagine, and a jury can infer that the further down you got to the steps, the darker it got, because you're further away from what little ambient lighting was coming from the overhead sealed staircase. And this is not an open staircase. In other words, the light from the top of the staircase doesn't shine directly on the bottom of the steps. It's a closed staircase, as the pictures depict. So
well, that's why, Mr. Zuckerberg, that's why I asked that question, because I thought it might actually bolster your characterization if he was saying, it might be that the light at the top is a perfectly, bright light and it still didn't come around the corner. But if he was saying that the light at the top itself was dimly lit, so even the thing that might be making it possible to walk down these stairs and see something itself is dimmer than it's supposed to be. I just wondered if he was referring to that light. Something you said before made me think if that phrase was modifying the light as opposed to the conditions overall in the stairwell.
Again, I think it's a jury question, but the testimony, again, in the light most favorable to the appellant was the light was off, and because the light was off, he couldn't see the steps.
Mr. Zuckerberg, what is your response to your opponent's alternative argument about assumption of the risk? The argument being that if the stairwell were as dark as you now are suggesting, that your client really should not have proceeded forward. He had alternatives. He wasn't forced to go on this tour. Why didn't he assume the risk of walking down a dimly lit staircase?
Well, this is again, a jury assumption of risk and contributory negligence are classic jury questions. He was obviously being led on a tour. He was following a group of people. And as he followed it, the light was off in the area that he was trying to follow his tour group. They could argue you should, I guess, separate yourself from the tour group, go in a different direction, leave the tour guide. I don't know what they're saying. You should have stopped there and waited or called the fire department, but they haven't really said what he should have done. But obviously, it's a jury question whether he was reasonable to continue to follow along with the group and try to use the handrail for what he tried to do was to use a handrail to steady himself. And that was the second portion of the case, which is the handrail had failed previously and failed again when he fell. So I think it was reasonable for him to grab the handrail. That was a reasonable.
Well, there are, of course, some things that are jury questions, but then there are some situations where a court can find as a matter of law that no reasonable jury could conclude whatever we're talking about. In this case, no reasonable jury could conclude that your client did not assume the risk by going down a dark or dimly lit staircase. Is this that situation? I'm sure you'll say no. So the answer really, my question is why? Why isn't it?
Well, he grabbed the handrail for support when he couldn't see it. He grabbed the handrail for support, and I think a reasonable jury could find that's reasonable. That's why handrails are there, and you can grab the handrail, and that's when the handrail gave way and he fell. So I think he was reasonable in grabbing the handrail, and I think the jury.
Are the facts that he grabbed the handrail when he started to fall, or was he holding the handrail all the way down? It's the
He
former.
wasn't holding the handrail all the way down. He grabbed the handrail for balance. Correct. And a jury could find that that's reasonable. There's
when
no
he-
requirement. Yeah.
What is the testimony about what happened to the handrail when he grabbed it for balance?
It gave way under his weight and it moved and it wasn't able to balance him and he fell.
How did it? That's how he describes it. How does it give way? I mean, I take it didn't collapse. I'm trying to figure out what exactly happened according to the evidence when he grabbed the handrail.
It was loose and it moved under his weight, and he
Well, how
wasn't
much did it move?
to steady himself. It moved sufficiently enough that he wasn't able to provide balance for him to grab it. That was his testimony. It wasn't, there wasn't a testimony as to distance, but it's interesting that their expert came and said that just applying nominal pressure to that handrail moved it. And the expert didn't say how much it moved it, but their own expert said, I applied nominal pressure and the handrail moved. So if
I
it
thought
moved
I
under-
remembered reading something to the effect that their expert testified that 100 pounds of pressure, I'm not sure in what direction the pressure was applied, but that applying something like 100 pounds of pressure on the handrail or banister, whatever we call it, moved it about a half an inch.
They didn't say a half an inch, they say it moved it. He never measured it. That's one of the reasons why I moved to strike his testimony, but it did move on 100 pounds. And here we have, a grown person coming down, and you have not only his weight, but gravity there as well. So it certainly was loose. And obviously, if you look at the handrail, it had failed a reasonable jury can conclude that it had failed previously. It hadn't been restored to its prior condition. And it was just thrown together in a slipshod way. It had used a wood screw to hold it together, a single wood screw. The balustrade was missing. In fact, their expert testified that the main support beam had rusted through, and that's why there was these brass straps on the side. So it was a terrible looking handrail, and it had failed previously. So it's more likely than not, given the fact that he needed it at the time, and his, was that it also gave way when he tried to rely on it. So this is about as basic a negligence case from our perspective as you could find. The stairwell was dark. The handrail was obviously in a defective condition. a reasonable juror can make these decisions. The same questions your honors are asking are what the jury should be doing. And it would close the courthouse to many plaintiffs if, as the defendant suggests, you had to have experts come in, do destructive testing on this handrail, and do sophisticated luminosity tests, would raise this to a NASA level litigation when it's the most basic type of personal injury case where they didn't turn on the stairwell lights for this tour, and they never bothered to repair the handrail after it failed previously.
Your
So-
reference to it failing previously, is that an inference from the fact that there was this wood screw, or is there information in the record about some event where it failed previously?
That's the juror can make the inference from the looking at the handrail that it had broken off from the wall and the original hardware is not there. In fact, the support beam that's right under the handrail is missing. You could look at it, it's not even there. The metal support post that's supposed to hold it up is not even there. It's not even in the picture. There's a huge gap between the railings that are supporting the top of the banister. It's not even there. The support beam is gone. It's not even.
Yes, I understand.
Yeah.
I saw the pictures. Excuse me. I was really just asking about your statement that it had failed previously.
That would be an inference that the jury
All
could
right.
make
I was
based
gonna
on
say,
the
because
situation
you
that
could
it
at
had
least-
broken and been repaired.
Right.
in a
You could
slip shot
imagine
manner.
situations where some repair work was done, but it had not failed before the repair work. Somebody might have just been inspecting it, for example, and said to themselves, I think I'll replace this screw because who knows, in the future it could fail.
Well, their
But you're
expert said,
drawing an inference.
no, their expert testified that the main support shaft had rusted through. That was in their expert report. It had completely rusted through. So that would be considered a failure. And that is why those straps were on the side, because the main, I can't remember the word he used, the main post, steel post inside the balustrade had rusted through. That was in his report. So that was a failure. Rust had caused it to fail. That was in the record.
Okay, let us hear from Mr. Ferguson, and Mr. Zuckerberg will give you a few minutes to rebuttal.
Thank you so much.
Mr. Ferguson?
Good morning, Your Honor. May it please the court. Robert Ferguson on behalf of the appellees. Let me read from Mr. Kenny's deposition. And that can be found at the Joint Appendix, page 159 to 162. And it also appears at Joint Appendix 239, where our expert's report is a part of the appendix. Question to Mr. Kenny, but you noticed it was dimly lit. Answer, there was only one light bulb, but did you notice it was dimly lit? You could tell it was dimly lit. When you got to the bottom, was it the very bottom of the stairway that was dimly lit, or was it the room that you were entering? It was the room. As I stated earlier, I think there was one light towards the top, and you could see the floor because it was dark at the area. Now, there's a room at the bottom of the stairway that Mr. Kenny testified did in fact have a light in it. Our expert, Mr. Saunders, made an assessment of the adequacy of the lighting and the adequacy of the handrail. Both lighting and handrail strength were issues that were raised in Mr. Kenny's complaint. He has the burden of proof to establish that the handrail was deficient and the lighting was deficient. Both handrail strength and lighting levels are governed by not only design, but code. And these are engineering and architectural principles that Mr. Saunders is qualified to testify to. Both conditions lighting is measurable. The strength of the handrail is measurable. Mr. Saunders' report indicates that he used an instrument to record the lighting levels at the bottom of the stairs. And in fact, it's interesting, the very last step that Mr. Kenny says he lost his balance on was much higher lumens than the stairs above it. The code requires, according to our expert, only 1 lumen to illuminate a stairway. He measured 18 at the bottom of the stairs and 17 and 16 as it goes up.
Mr. Ferguson, can I interrupt? I'm sorry, but how do you deal with Prosser on this, Prosser on torts, saying that it's an everyday experience that an unlighted staircase creates a danger? How does that fit in with your point that this is all, we need some scientific assessment or measurement?
Well, the quote from Prosser is an unlit stairway or an unlit area. And that is not the evidence in this case. Mr. Kenny testified there's a light at the top of the stairs. And when he went down, the light at the top of the stairs was on. The bottom of the stairs was dimly lit. And the room at the bottom of the stairs had a light in it.
But if you said that the light at the bottom was not on, in the light most favorable to him, isn't that, an unlit staircase?
No, it's not, because there's ambient light from the room that is at the bottom of the stairs. He did testify that the light near the bottom of the stairs was not on that day. The light at the top of the stairs was on, and in the room adjacent to the bottom of the stairs, there was a light in the ceiling. And you can see those in the photographs in our expert's report. And the expert report is found beginning at Joint Appendix 235. There's photographs that show the room at the bottom of the stairs and the location of the lights in the ceiling of that room. So you have ambient light from the room at the bottom of the stairs, and you have quite clear light from the light at the top of the stairs. Prosser posited a situation that was no lights on, dark. And which brings me to another point. Counsel for appellant indicated that the answers to interrogatories by Mr. Kenny state that it was dark. The answers to interrogatories, if you look in the record, at the very beginning, there's an introduction that says the choice of words is that of counsel. We had those answers to interrogatories and decided to take Mr. Kenny's deposition. And Mr. Kenny decided to choose the word dimly lit. Mr. Kenny testified that there were actually lights on that stair. This is very similar to the case we cited of Briggs versus WMATA, where they had a temporary barrier around the walkway leading to the escalator. And the testimony was that it was dimly lit. And the court granted summary judgment because dimly lit was not sufficient for a jury to decide the case. The plaintiff had to name an expert who could actually measure it and tell the jury how dim it was or how bright it was. The code addresses what level of light there should be, and the parties have the right to identify an expert who can scientifically measure that level. We did that.
So do I understand that with regard to the lighting, your position has 2 parts? One is an expert is needed to measure what the lighting was. And then 2, an expert was presumably needed to say that lighting exceeded code requirements, applicable code requirements. And it's the determination that the lighting, in your view, it's the determination that the lighting at the scene exceeded applicable code requirements that answers the question of whether there was reasonable care?
Yes, Your Honor.
So the plaintiff cannot say, look, I don't care what the code says. I'm not bringing forgive my slightly, I don't know what the right word is, casual way of putting it. but in effect, you're saying, even though this is not a negligence per se case of you violated, the plaintiff saying you violated the code, you're negligent, you're liable. The code basically sets the applicable standard of care, and the plaintiff can't come in and say, in effect, look, that may be what the code says, but I'm telling you that a reasonable person would find that too dark.
Well, that's quite a stretch for a layman.
I'm a reasonable person, and I found it too dark.
I think that's a stretch for a layperson, where the code stipulates that it needs only one lumen, where instruments can be used to say exactly how dim or how bright it is. For the plaintiff to say, my client should be governed by a different standard that he chooses, not the District of Columbia building code. And the same goes with respect to the handrail. Our expert measured the strength of that handrail, that it would withstand at least 100 pounds of force. And he says it moved a fraction of an inch. And that's at page joint appendix, page 261. Fraction of an inch is nothing. And he opined, after reporting those measurements, that the strength of the handrail with the braces that had been put on it was adequate. There's no testimony to refute that. We have cited quite a number of cases where the trial court has granted summary judgment where they have not had an expert to testify about the strength of some construction material or the adequacy of the lighting levels. In this instance, we think that Judge Sadler exercised discretion under the circumstances, reviewed the evidence, and found that with the defendant's expert's testimony demonstrating what is needed to qualify or quantify the strength of that handrail and the level of lighting, that the plaintiff should have had an expert and did not.
With regard to the strength of the handrail, my question in a way is similar to the one I asked before. The expert testifies that 100 pounds of force applied in such and such a way, and it moved a fraction of an inch. Now, that's by itself, that is not establishing a standard of care. That's just a measurement. What is it that establishes a standard of care? That's sort of part A of my question. And part B is, well, what do we do with Mr. Kenny's testimony that when he relied on the handrail, it didn't, now this may be imputing a little bit to his testimony, but it didn't just move a fraction of an inch. It moved seriously enough that I lost sufficiently that I lost my balance.
His testimony, well, first of all, our expert, once he quantified the amount of force that was able to be withstood by this handrail, he then formulated an opinion and wrote that opinion in his report saying that it was adequate. And that opinion, that the force it withstood was adequate, is not refuted anywhere in the record. And those two factors, the measurement plus the opinion, establish that the standard of care has been met. Same way with the lighting. The measurement plus his opinion.
We normally say, that we expect expert opinions in these areas to testify to a national standard of care. What was the expert's, saying? I mean, I can well understand from a layperson's point of view that if it only moved a fraction of an inch, that sounds adequate to me. But what do I know? I'm not an expert. How does the expert know that that is adequate? In other words, an expert merely saying, I've seen handrails and this one only moved a half an inch or whatever it is. And that's adequate. Well, where's the standard of care in all that?
His report and his CV set forth his qualifications to form opinions about the strength and adequacy of materials and building materials. And he recites the research that he did into the DC Building Code and the fact that this is a national historic building and that what codes would apply to it. And he compared what he measured with the existing building code and formed an opinion. That opinion was that it met, that it was adequate to serve its purpose, and that opinion has not been refuted.
I need to look again at the expert report. I didn't finish reading it, but does the expert say something about how much force Mr. Kenny was likely to have exerted on the handrail? I understand he says that applying 100 pounds of force, it moved only a fraction of an inch, and I may not have said that correctly. But I guess I'm wondering, and that's why I need to look at it again, how much force Mr. Kenny might have placed on it. I assume he weighs more than 100 pounds. I guess I'm also assuming that it's not all your body weight necessarily that you put onto a handrail, but does he say something about that?
He does not, because Mr. Kenny testified that he did not have his hand on the handrail as he went down the stairs, and he just grabbed for it when he missed a step at the bottom. And the extent to which he was able to grab that handrail is not well defined in the record. And he does say it moved, but he doesn't say how much it moved. There were no changes to the handrail between the time of the incident and the time our expert looked at it. And our expert couldn't get it to move more than a fraction of an inch with 100 pounds of force.
I beg your pardon, did you say there were no changes between the time of the accident here and when the expert looked at it?
Yes, Your Honor.
I want to be sure I heard you correctly.
Our chief engineer, Mr. Hale, testified to that.
Is that also true with respect to his analysis of the lighting, that there were no changes?
That is correct. There had been no changes to the lighting on that stairway between the time of the occurrence and the time that our expert measured it. It was the same situation. Mr. Hale, our chief engineer, I believe, testified to that as well. I'd like to briefly address, if I may, Judge Sadler's order. Her order granting summary judgment and implicitly denying plaintiff's request for leave of court to name an expert. And her ruling implicitly and effectively denies that request. It was not a well-formed request. It was made after the discovery deadline. The scheduling order stipulates that all discovery motions must be filed prior to the discovery deadline. And the request was made in such a form that if the court is going to require an expert, may the plaintiff have an expert, have leave to get an expert. That is somewhat like an advisory opinion, which most courts decline to do. In other words, the plaintiff is asking the court, if you're going to say I need an expert, please give me time to get an expert. Well, that was up to the plaintiff to decide. He had a strongly founded strategy in this case, and he articulates it in his opposition to the motion for summary judgment for the first time, never asking leave of court to move his deadline for naming an expert. And I think that Judge Sadler had more than enough reasons in the record to deny that request because it was willful violation of the scheduling order. It was going to be prejudicial to the defendant, and it was, I think, all of the pardon me, all of the factors in the Weiner case are addressed by plaintiff's decision, conscious decision not to name an expert until the court required it. And by then it was too late because all of the deadlines had passed. That's all I have for now, Your Honor, unless you have any questions. Thank you.
Thank you. Mr. Zuckerberg, you'd like to take a few minutes in rebuttal?
Thank you. First, the lumens test by the defendant's expert was done with the light on. It was done with the lower light on. He never tested the lumens with the light off. So we didn't believe that that was relevant because the light was off. Likewise, to answer Judge Glickman's.
May I interrupt you about that? There seems to be some ambiguity here. If I understood correctly, there is a light bulb in the ceiling at the bottom of the stairs. And in addition, there is a room at the bottom of the stairs, which also had a light in it. Have I understood that correctly?
That was Mr. Kenny testified that there was no light coming from any other room on the bottom of the stairs, that the door was closed and that there was no light was his testimony at deposition. So the only light that he testified was whatever that light from the top of the stairs. And the quote, counsel misstated the quote, and I think it answers Judge Beckwith's question. It's on Mr. Kenny's deposition. It's Joint Appendix 161. And the question was, when you got to the bottom, was it the very bottom of the staircase that was dimly lit, or was the room that you were entering? And the answer was, it was the room. As I stated earlier, I think there was one light toward the top and you could not see the floor because it was dark in that area. That is the bottom of the area. You could not see the floor at the bottom of the stairs because it was dark. That was the testimony on page 161. Again, answering Judge Glickman's inquiry, no, their expert did not have any national standard of care. He just dreamed up this 100-pound standard. It's not in any code section. It's not found anywhere. It's not the national standard of care. And if you think about it, handrails wouldn't be much use if the standard were 100 pounds because the average person is in excess of 100 pounds, and then you have gravity as well. So if all that was required of handrails was 100 pounds, people wouldn't be any use to it. Mr. Kenny's a grown man, obviously well in excess of 100 pounds. And when he grabbed it, he moved. They never attempted to do a test. They're saying we have to come up with testimony that their expert never testified to. That is, what would it have moved under circumstances similar to the facts in the case, which is someone.
Well, actually, you have to come up with testimony to prove your case.
Well, the point
You
is,
have the burden of proof. They're not really saying, I don't think, that we should rely on the experts, on the defense experts' testimony here. What they're saying is there's a gap in your proof that justified the court granting summary judgment to you.
well, it shows how their expert report shows how futile expert testimony would be in this case, because we'd have to somehow reach some agreement as to what forces Mr. Kenny exerted on that through some type of technological, and then have that applied in some destructive testing of the handrail. And we'd have to do some NASA type evaluation. And that's just not practical in a case like this, and it's not necessary. It's within the ken of the average juror. They didn't turn on the light and they didn't fix the handrail, which had obviously failed previously. And he explained why it failed, because it had rusted through. That's their own testimony. So it's within.
So you think that if the evidence at trial were simply, I started to fall, I grabbed the handrail, it moved a fraction of an inch, and I lost my balance, that would be sufficient for the jury to find that there was a breach of the duty of care on the part of the hotel in the maintenance of the handrail?
Well, he said it moved sufficiently enough, so it moved enough that he wasn't able to, he never said a fraction of an inch, he wasn't able to regain his balance. And then he looked at it and it looked had failed previously and it hadn't been properly repaired. That's why an expert on the testimony of what hotels were like in 1910, which is what the court said we needed, was illogical, because it obviously wasn't in the condition that it was in 1910 when it was built. It had failed. It had broken before. It had broken because their experts said it had rusted through, and when he needed it, it moved. That is circumstantial evidence that corroborates the client's testimony that when he grabbed to regain his balance, the handrail moved and he wasn't able to sustain him, and he fell. So, and if you look at the handrail, it makes perfect sense. This is all within the ken of the average juror. No expert testimony is needed here. And it's clear. Yeah. Are there any further questions from any of the?
I think not. Counsel, thank you both. The case is now submitted, and you may log off.
Thank you. Have a wonderful day.
This honorable court is now adjourned.